firstly, welcome to our webinar for employment law and commercial law advice through the Greater Birmingham Chambers of Commerce. My name's Chris Brewitt and I'm the Lichfield and Tamworth division head for the local division of the Chamber of Commerce. We welcome Keelys Solicitors, who are based in Lichfield, and also Rutherfords, who are based in Tamworth, so two local businesses who are active members of the Chamber of Commerce locally, and it's great to have them on board today. Next slide, please, Jess. So you'll see as a quick intro, I know there's quite a few people who are members. For those of you who aren't aware, we have various different divisions. So we've got Lichfield and Tamworth, Sutton Coldfield, Solihull, Burton, Cannock Chase and Birmingham, and also 4 other divisions that aren't geographical, so Future Faces and our Asian Business Chamber, our Transatlantic Chamber and our Commonwealth Chamber. We would very much encourage you to engage with us on various areas. Next slide, please, Jess. You'll see we have various membership levels. So again, if there's anyone on the call that is interested in membership following this, please get in touch. But we cover businesses from startup, from one-person bands, right up to large corporations and large businesses across various geographical locations. Next slide, please, Jess. As you'll know, obviously, because you're on the webinar, we have a webinar series at the moment that are across all of our divisions, running really advice, sectors, support, and topical discussion, sometimes based around COVID-19 and the coronavirus situation, others around education we've done and to supply and opportunities, as well as the Commonwealth Games, and there'll be many more. So please follow us on our various channels. On to the next slide. As said, there we are, just on cue. You'll see our various different channels. So again, Twitter, Facebook, YouTube and LinkedIn. Please do follow us and engage with us on those channels. We very much welcome your support and advice, and also feedback on the current situation as businesses. This webinar will be on YouTube. It is being recorded live, so no pressure, Paul and Natalie. But we'll have this up onto YouTube for later next week for us also to share across our areas as well, which is fantastic. Next slide, please, Jess. Again, various ways to raise your profile through Member Marketplace, feature on our newsletters, which are regularly sent out across the different groups and on a daily basis for our main newsletter. Again, a great way for you to send your own PR through, but also keep up to date with a lot of the comments and news from various businesses across Greater Birmingham and beyond. Next slide, please, Jess. Our policy, of course, has been very important. Brexit was a huge part of what we did earlier in the year. Now, of course, is COVID-19, which really has changed the way businesses work and the chamber works, and very important that we get feedback on various areas. The main one at the moment is our Mind the Gap campaign, which is very much around ensuring that the government and key partners, key stakeholders are aware of some of the struggles and challenges businesses are facing in this time. And we again welcome your engagement on that. Next slide, please, Jess. So again, you'll see more support for us, for you as businesses, as members. And again, if you want any more information, please contact us later on or go onto our website. Next slide, please, Jess. And finally, international services. I saw there was a few members I know who use our international services in terms of documentation, translation advice, and various other areas. Again, if you're as a business involved in international trade and you come under our area, please do get in touch with us on this. Next slide, please, Jess. And that brings us, following on to the bit about the Greater Birmingham Chamber, our 2 speakers. So again, a huge thanks for their involvement today. We have Paul Roberts from Keelys Solicitors based in Lichfield. Paul spent 14 years at Keelys, 20 years qualified, and advises over 300 clients on a retainer around employment law. I know there's a number of clients of his clients on here, so it's very much a great welcome to Paul, and also Natalie, who works at Rutherfords based in Tamworth, Paul is first up, so I'll give Natalie her introduction following Paul's presentation. And with that, Paul, welcome aboard. Thanks so much. And I will pass over to you now to give your presentation. Thank you very much. Just one final thing on the Q&A side in the chat boxes. If you do have questions, I can see there's a couple already come in. Please add them to the chat. And at the end of both the presentations, we'll have a 15 to 20 minute Q&A where hopefully we'll answer some of your questions and your queries. If you can use the question mark logo on the chat area as well, that is highlighted best for Jess to work. So Paul, over to you. Thanks very much, and I shall see you in a moment. Thank you.
Okay, well, good afternoon, everybody, and thank you to Chris and Jess for organising today's webinar. Until the last few weeks, I'd never taken part in a webinar, and this is now the 5th webinar that I've spoken on. So that's been a new concept that I've had to get to grips with and learn about. The other big new concept, apart from homeschooling, that I've had to learn about over the last few weeks is the furlough scheme. And I know many of our clients and we ourselves have used the furlough scheme. So I'd like to pose the question in a poll, if Jess can bring that up, just to ask you, how many of you have furloughed your staff? So if you could answer that, we'll review your answers later on. Well, the headlines around the furlough scheme are pretty straightforward, and hopefully you're familiar with them by now. Essentially, it can be used by any employer, apart from those in the public sector, and it can be used for any employee. The only criteria really is that somebody has to have been paid through the payroll prior to the 19th of March. So I think the rationale for that is that HMRC want to avoid people really fraudulently using this scheme. And so to avoid that, they want to be able to see that you have actually paid someone through your payroll before the 19th of March. So that really is the only criteria. You can then claim up to 80% of people's pay and up to £2,500 per month. Originally, the scheme was put in place until the end of May. It was then extended until the end of June. And we're waiting to see if it will be extended any further. So the short answer is no. People can't work while they're furloughed. You can do various things with them, though. They can certainly carry out training. The guidance makes that crystal clear. You can keep in touch with them. We don't want just employees to think we've forgotten all about them. So, for example, at Keelys, we've been having a weekly quiz with our staff, whether they're furloughed or not, which I think people appreciate just as a way of keeping the lines of communication open. And if you need to consult with staff about specific things, like perhaps redundancy, you can do that too while they're furloughed, and it may be done remotely. One of the main questions we were asked was, can you take holiday while you're furloughed? And that was our main frustration really with the government guidance, because it didn't answer it, despite the fact that we've just had the Easter holidays, and so it was a very live question. But belatedly, the government said, yes, you can take holiday while you're furloughed, but if you're paying staff 80% of pay while they're furloughed, you need to top that up to 100% for any periods of holiday so that you're complying with the working time regulations. If staff have already got holiday booked, you can insist that they still take that, even if their plans for holiday have probably been scuppered. If you want to, you can even require staff to take holiday while they're furloughed, which is quite attractive because HMRC are then effectively funding your holiday pay. And also you won't have staff with vast amounts of holiday to take when hopefully the world gets back to normal. How does it work then if you're furloughed for part of the month? The HMRC guidance is very clear on that. What you have to do is prorata people's salaries based on calendar days. We're normally used to thinking about working days, but it's very clear you base it on calendar days. So, for example, for April, you would divide their monthly salary by 30 to get the number of calendar days, and then you multiply that by the number of calendar days that they were furloughed in order to work out what you can claim from HMRC. Does this prevent you making redundancies? Well, the purpose of the scheme was to try and avoid redundancies, try and keep people in employment. But the answer is no, this doesn't prevent you making redundancies. And sadly, we've already been working with some of our clients on making redundancies. And you need to consult with your staff before making redundancies. But having done that, once you give notice, employees could be furloughed during the notice period, which again is quite attractive for you because HMRC then effectively funding the notice pay. Is it likely to be extended? Well, hopefully we may get some hints from that about that from Boris on Sunday. But the government are already talking about weaning us all off the furlough scheme. My guess is that will be done on a gradual basis. So perhaps the percentages that we can claim will be reduced. Perhaps the sectors that it applies to will be limited. And maybe it will also work on an individual basis. So if, for example, we've got employees who need to shield because they've got specific health conditions, the furlough scheme might apply to them for a longer period of time. And I wouldn't be surprised if we see a combination of all of those three being announced. So watch this space as far as that's concerned. But already the government are making it quite clear, as far as possible, they want us to get back to work if possible, to get the economy going again. If we can work at home, then the government will, I think, continue to encourage us to do that. If people can't work from home, then they will need to go to work, and they can do that at present. But clearly that needs to be done in a safe way. And the guidance has issued, the government has issued guidance for specific sectors on social distancing in the workplace. So if you are requiring employees to come to work, or you're going to be doing that in the next few days or weeks, I would find that on the government website. It's quite easy to find. And you can then comply with the specific guidance for your sector. But as far as possible, the guidance will remain to keep employees 2 meters apart. That will be the headline, I think. But in principle, you can require people to return to work at any time. They can be required to return to work from furlough at any time. The only point to bear in mind is that they have to be furloughed for at least 3 weeks at a time in order for you to claim from HMRC. What if they don't want to return? Well, there could be lots of different reasons for that. But in general, you can say to an employee, if you don't come to work when we're asking you to do so, then you won't get paid. If you're really keen for employees to come to work, you could even threaten to terminate their employment if they don't. But if the employees are saying that they're reluctant to return for health and safety reasons, then you should tread carefully. Because under existing law, if an employee isn't willing to come to work because of health and safety concerns, and you terminate their employment as a result, they will have an automatic claim for unfair dismissal. So in those sorts of scenarios, you should be taking advice from us or whoever you go to for legal advice to make sure you don't have claims for unfair dismissal. So those were really my FAQs that I've been asked over the last few weeks. But I'll be sticking around, so please put any more questions in the chat, and I'll be happy to answer as many of those as we have time for at the end. Thank you.
Well, but it looks to me like we are all back on board, so we can start with the next presentation. Natalie, just want a big thank you for Natalie's involvement again with those Q&A's questions that I can see there's some through, so continue to send those through. On Natalie's side, obviously a huge welcome again. Rutherfords, as I said, are based in Tamworth and very much work around commercial law and advising around that sector and that area. Rutherfords are a real key engager in terms of the Chamber of Commerce in Lichfield. Natalie and her colleague Lauren Henderson have been at various events, and Lauren is also on our executive board. So again, a really engaged business locally and across Birmingham. Natalie has been at Rutherford since March 2019 and has been qualified for 11 years around advising on commercial properties for small SMEs to larger national companies. And as said, Rutherfords are based at Ventura Park in Tamworth. I'll pass you over to Natalie now. As I said, get the questions in the chat box, and we'll come back and have both Natalie and Paul answer some of those questions in a few moments' time after Natalie's presentation. So over to you. Thank you.
Thanks, Chris. Again, just echoing what Paul said about thanks for arranging this. I think it's really useful for individuals, businesses out there to just get some guidance and information on really what is quite an uncertain time for a lot out there. So I think this is really helpful. So in terms of business tenancies, I'm just going to go over some information and queries that we've been seeing, really particularly centred around a tenant's inability to pay rent due to possible cash flow, long-term viability of the business, that kind of thing. So the Coronavirus Act was introduced on the 26th of March 2020, which included a protection for the tenancy, for a tenant under a business tenancy from forfeiture. So what this effectively means, it's for the relevant period which is from the 26th of March 2020 to the 30th of June. A landlord cannot basically force a tenant out of its premises if it hasn't paid rent. Now, at the moment, this does only apply to business tenancies. So if you occupy your property under another type of tenancy arrangement, such as a license, for example, is quite popular, then this won't apply. This doesn't constitute a waiver by a landlord of its rights of re-entry. A landlord will still have that right unless it expressly waivers it. So if it says to the tenant that they won't have that right at all. What the government is encouraging, obviously, is tenants to still pay rent where possible, because a lot of landlords are commercial entities themselves. They will have liabilities themselves to pay, probably mortgages, funding that might be secured against the property. So it will still be due. And that needs to be taken into account in terms of what kind of arrangements you might come to with your landlord. So with that in mind, can I have the next slide, please? Thank you. If you are a tenant and you're struggling to pay your rent, then I would very much encourage you to speak directly to your landlord, have an open, honest, frank discussion and be proactive where possible. What we are finding is where that parties do have good relationships and have those open discussions, parties that feel a lot more comfortable about agreeing to various options going forward. Now, the various options that might be available to the parties, I've set out, and if we just quickly run through them so that people can see what might be available. So the first one is rent deferment. Now, what this means is the tenant is given a break by the landlord from paying rent for a set period of time. Now, that may be attractive for a lot of tenants at the moment, but generally with rent deferment, that it is just what it says in the tin, you're only deferring the rent. So in all likelihood, the landlord is going to require you to pay by additional rent at some point in the future, and by equal periodic payments over a specified period of time. So it is going to be payable at some point, it's just maybe not in the short term. Another option might be to change the way in which rent is paid. Now, most leases will require rent to be paid quarterly. It might be that a tenant would prefer at the moment to pay monthly, although I would say that if cash flow is an issue, that might not be the most attractive option, but it is something to consider. A third option might be a rent reduction. Again, pretty much what it says on the tin, pay less rent for a set period of time. This might link up to the deferment. You pay less rent now, but then top up further down the line with the difference. Another option might be rent abatement. So in this arrangement, the tenant is not required to pay rent for a specified period of time, nor would it be required to top it up I think from a tenant's point of view, that's probably the most attractive, because obviously they're not having to pay it now and won't incur the additional liability in the future. Fifthly, and really this is only going to be applicable where a tenant has paid a rent deposit either at the outset of when they entered into the lease or at some point as the lease was continuing, a landlord with the agreement of the tenant could draw on the rent deposit, but the landlord's probably going to want the tenant to top that up at some point again in the future. There are obviously pros and cons for each option, and I think what is right will very much depend on the circumstances and not what of both parties really, and what's maybe considered long-term viability. For example, obviously anything that can help the tenant and ease cash flow at the moment is going to be attractive to the tenant. But bear in mind that options 1 and 5 and possibly 3 are still going to require the tenant to pay out at some point in the future. And in terms of deducting from the rent deposit, that might not be attractive for a landlord, as if the tenant is unable to pay or defaults on the lease sometime in the future, then they are going to struggle to recover through, because there's no money there left in the rent deposit. I would say whatever is decided, and this is very much what we're saying to clients at the moment, whether tenant or landlord, you should document that arrangement in writing so that all parties are clear on what's expected of them, and how long it will last, for example, what it actually means for each party. As I've said, what is right very much depends on the circumstances. A tenant will be looking to alleviate any financial pressures, and a lot of landlords we're working with do understand this, but it needs to be recognised as well that landlords are commercial enterprise in themselves. So if a landlord has a mortgage or a charge secured against the property, which it needs the rent to pay, then if they don't have this income, then they may well be in breach of their lending covenants as well. At the same time, from a landlord's point of view, they need to think pragmatically and commercially. So even if a tenant isn't necessarily paying rent now, it might be advantageous for a landlord to have a tenant in situ, as in most cases an occupier is responsible for business rates and other outgoings. So as well, depending on the nature of the building, if there are common parts, for example, the tenant may be obligated to contribute towards a service charge, insurance, that kind of thing, any other maintenance costs. The landlord just needs to bear in mind, if the space is empty, then they would be bearing those costs. Have the next slide, please, Jess. Just quickly want to mention and touch upon any means of recovering rent that would have been available pre COVID-19 and are in some regards still available, but the way in which they're exercised, the period in which they can be exercised, have been altered or amended by government legislation. So we have heard of some landlords threatening to serve statutory demands on tenants where rent is not paid. Now, previously this was attractive to some landlords, as it can prove successful because it is a precursor to insolvency proceedings, which some tenants might want to avoid. However, what I would say is that the ability for the landlord's service of statutory demands in the current climate has been curtailed, so that any demands issued between the 1st of March and the 30th of June cannot be used to support a winding up petition. Furthermore, in terms of any winding up petitions sent to the courts between the 27th of April and the 30th of June, the courts will review the reasons for the tenant's inability to pay its debts. And what the courts and the government what the government have said is that you know, where there is an inability by a company to pay its bills as a result of the coronavirus, then they are protected against any unscrupulous landlords or anyone trying to enforce that debt. Now, the difficulty with a lot of the government guidance at the moment is it's not entirely clear how a company's inability to pay its debts or its bills will, as a result of the coronavirus, will be interpreted. For example, it may be that a lot of businesses were struggling pre-coronavirus, and this has just exacerbated the situation. I think it's going to be left a lot to the discretion of the courts to determine exactly what this means and how it would work in practice. What I would say is I suspect that the insolvency courts may take a rather dim view of any such steps that are taken in the present climate. Also, if landlords are still able to commence court proceedings for recovery of rent, then they are likely to be slowed because of the implementation by the courts of any new measures, which will continue to be kept under review. Another option that is open to landlords who have been considering where rent is unpaid is the commercial rent arrears recovery method. So this is a form of enforcement to recover rent arrears relating to commercial property, which allowed landlords of business premises to recover goods and sell them to cover unpaid rent. Now, previously, the amount outstanding had to be equivalent to 7 days, but recent legislation has extended this to 90 days. So it's going to be, in 90 days is quite a large extension, and effectively almost covers like the 3-month relevant period that, you know, the relief from forfeiture. So that's just something to bear in mind. I think also from a practical point of view, given the social distancing and guidance from the government, a landlord is unlikely to be able to gain access to a premises anyway, and I do think that any attempt to do so might incur wasted costs on behalf of by enforcement agents. So, you know, it's just something to bear in mind, again, from a practical commercial point of view. Have the next slide, please, Jeff. And finally, on the topic of commercial property, this is a couple of queries that we've had in relation to health and safety. So tenants are most likely going to be subject in their leases to an obligation to abide by all laws applicable to their occupation. So if, for example, a tenant has employees or visitors to the premises, clients, customers, that kind of thing, it will have to abide by any health and safety legislation, which most likely will require the carrying out of risk assessments and consultation with employees, arrange for effective planning, organisation, control, monitoring, that kind of thing, and review of preventative and protective measures. And also, you know, paying close attention to what government guidance is issued. And I think we'll probably know more about that on Sunday, and what the government proposes to do in terms of coming out of lockdown and how that will look in the workplace. From a landlord's perspective, again, a landlord may employ people to carry out maintenance, for example. Those duties that a landlord has will be similar to those that a tenant has. And coronavirus has been classified as an infectious disease. So where there are common areas, for example, which a landlord maintains, it may want to consider additional measures to prevent the spread of infection. So, for example, a deep clean is something that a lot of landlords and even tenants have been considering. It can be quite costly, but look at any service charge provisions that are in the leases and see if there's any wording in there that will enable a landlord to recover the cost from the tenant through the service charge. Next slide, please, Jess. So just quickly moving on briefly to talking about contracts and in particular what is known as force majeure provisions, which are very much coming into play and being considered at the moment, where perhaps businesses are struggling to fulfil a part of the contract or comply with certain time limits because of workforce just not being available, whether they're off sick or because of social distancing, or delivering of goods being held up in the supply chain, or held up, even importing goods being held up at ports, that kind of thing. So COVID-19 has been affecting supply chain and performance of contracts in a number of areas. And where this is the case, one or both parties may be able to rely on the principle of force majeure. So this is a principle where one or more of the parties is entitled to suspend performance of its affected obligations in a contract and or claim an extension of time for the performance following the happening of something that is beyond their control. Unfortunately, unlike other jurisdictions, this is not a principle enshrined within common law, nor is it a statutory principle. So it must be included in the contractual agreement between the parties. So therefore, what that means is you have to look at the terms of any written agreements you have, and if it's not in there, you're not really going to be able to use it. Having said that, if it's a properly drafted contract, then you will generally find that a force majeure clause is in there. So assuming that it is, and when considering whether such an event has occurred, the following should be considered. I would just say quickly at this stage that what I'm putting here is, what I'm saying here and what's on the slides is for guidance only, and each case does very much turn on its own merits and looking at the individual wording of each clause. And really, advice should be sought on whether it's something that a party can rely on. But if we just have a quick look at things you might want to consider. So what does the clause say? Now, force majeure clauses fall into two different categories. One option is that it will list each clause. It will list what classes as a force majeure event. So often that will include acts of God, terrorism, acts of government, as well as often listing epidemic or pandemic. So if it does include if your clause does include a specific list, then that's great, because hopefully you've got over the first hurdle. If it doesn't, if it's just general wording, then you are going to have to try and argue that COVID-19 does fall within that clause. It is an epidemic. It has been classed as epidemic, pandemic by the government. So hopefully, and in all likelihood, you would be successful in arguing that. But as I said, it is very much going to depend on the construct and word of the clause. You might want to have look at think of the impact of the event. So what, and this is going to be set out in the clause. So what does the wording say in terms of when you can rely on the force majeure clause in the contract? So have you been prevented from performing your obligations, or has it been hindered or delayed them? Prevention basically means it's impossible for you to do what you're contractually obliged to do. This is a very high bar to prove. So really, you need to just prove beyond a doubt that it is actually impossible. If it's just a case of hindered or delayed, that's going to be a lower threshold. But again, just think about the effects of it if you're looking to rely on that. Is this an event that the parties could have reasonably foreseen? Did we see it coming? Did we see the effects of it coming? Could we have done something about it? Again, it's going to very much depend on your individual situation. We all know it came on very quickly, but again, it's something we need to think about going forward. There is a requirement on parties to mitigate any losses. So what steps could be taken to minimise the effect of the event? Usually such steps are going to be required to be reasonable. And then also think about what the consequences are for the parties. Usually the occurring of a force majeure event would allow the parties to claim relief or an extension of time. However, in some cases, the clause can go further to state that even where there would be an extension of time, if the delay goes on for too long, then the other party can bring the contract to an end and then possibly claim damages. So again, think about whether this is something that either party wants to happen. Next slide, please, Jess. So what's it? Oh, the one before that. So just think as well about any procedural requirements. You are likely to going to need to give notice if you want to rely on a force majeure argument and a clause. If there isn't one in the contract, as I've said, then it's not going to be available to you as an argument, but you can consider other options. So can you renegotiate the terms? Look at the rest of the contract. Are there any other clauses that you could rely on? As a last, well, not a last-ditch attempt, but another option is an argument for frustration, which is essentially where events have occurred so as to prevent the parties from performing the contract, or mean that the terms are radically different to what the parties intended. What I would say is frustration is not an argument that should be made lightly, because it will mean that the contract will be brought to an end. And it also is very, very difficult to prove. So it is probably going to be something that you are going to need specialist advice on, professional advice. So maybe speak to, something we can advise on, or whoever you use to provide your legal advice. Next slide, please, Jess. So just quickly, to sum up, I would say that whatever the nature of the relationship, be open, frank, honest with each other. As I said, what I have found is where parties have a good relationship, they do work together to achieve something that's workable for both. Think about the long-term objective. The business may be struggling now. Will it be able to get back on its feet? Take a commercial and pragmatic approach. Consider other options that are available, and this is particularly probably from a tenant's point of view, to ease the financial burden. Are there any government grants or the loans that have just recently been introduced? Are there any tax rebates you may be entitled to, so R&D, that kind of thing, VAT deferment or rate holidays, and the job retention scheme, anything basically you can use to maybe save a bit of money in the short term. Consult any professional advisors, whether it be legal advisors, tax advisors, accountants, that kind of thing. Those kind of people will be keyed up on your options and should be able to provide you with advice. Document anything that's agreed in writing, and we cannot stress how important this is. What we don't want to avoid is an argument or an issue where it comes down to he said, she said. The only people that benefit there are the lawyers, because it can just incur costs. And follow government guidance and keep up to date with all developments. I know it's a very uncertain time, and it seems like guidance is always being issued left, right, and centre. That's what professional advisors are for as well, I would say. So, and above all, brilliant. Stay safe.
Yeah, thanks, Natalie. Appreciate that. No, fantastic. And I think there's some really interesting themes there, Ray. So if I could ask Paul on as well, moving forward, and we'll start the Q&A. Natalie, thank you very much. Various questions. So, Keane, we've got about 15 to 20 minutes for the question. I know we had a little dropout in the service, so we should be able to cover a few more questions for a few more minutes. So we'll move on to the first question, which is from Lisa Evans. And if I can move my screen, I can see it. As furlough has to be a minimum of 3 weeks in order for the funding to be claimed, how does holiday and bank holiday impact on this? Is it 3 weeks plus bank holidays or including? And obviously, the way it's the timing that's happened, there's quite a few bank holidays in there at the moment. So, Paul, what's your thoughts on that?
It's 3 weeks, including the bank holidays. So you don't need to add the bank holidays on. All you've got to make sure is that you top the bank holidays up to 100%.
Okay, brilliant, brilliant. Hopefully that's helped. Lisa, as I said, this will be recorded, and we'll obviously give our contact details for the speakers to sort of give more detail if required. So next one is from Andrew Raven. I have an employee on self-shielding for 3 months, advice from the government due to pre-existing medical condition. If restrictions are lifted, can we enforce back to work?
Well, as the question implies, it all depends whether the restrictions are lifted or not. If they are, if the government are effectively saying it's safe for those people to return to work, then yes, you can enforce them to come back to work. Yeah. To be honest, I think that's probably unlikely. I think those restrictions will remain in place, in which case you can't force them to come back to work. And as I hinted at earlier, forgive me if it may have cut out, the government might keep the furlough scheme in place for certain individuals, like people like this, to support them until it is safe for them to come back to work.
I mean, as an employee, sort of law specialist, I suppose that's very important. Just I suppose for general employee well-being, isn't it? If the government are able to look at something like that, I suppose there will be some quite difficult decisions for businesses to make, and if the government are giving some advice on that, I suppose that certainly helps. I would think.
Yeah, well, I don't think the government are going to be encouraging people to go back to work if it's not safe for them to do so. But it is the government need to support us as employers and our employees, and until it is safe for them to come back to work.
Yeah, absolutely. Okay, no, thank you very much. Next one from Helen is: if you make an employee redundant whilst they are on furlough, do you have to top up their notice pay to 100%?
Yes, is the short answer to that.
Okay. Good answer, thank you. Lorraine Screen: if furloughed, can the individual work for another company, even if the company is a parent company, but they are registered and set up as a different company?
That's a good question. Generally, employees can work elsewhere, but they can't work for an associated company, which would be a parent company, a sister company, really any company that's controlled by ultimately the same people. Otherwise, you could just shuffle employees between companies, and HMRC wouldn't be very happy. So the answer is no to that.
Okay, thank you. Julie Muir: can you negotiate shorter working hours on a temporary basis?
First of all, check the contract of employment, see if that gives you the right to impose short-time working. If it does, then great, you can just do that. If it doesn't, then as you say, you will need to negotiate. If the employees are willing to agree, then that's fine. If they're not willing to agree, you've got a choice. You either keep paying them in full, whether or not they actually work in full, or you may have to say to them, look, if you don't agree to reduce your hours, we may have to make you redundant. That ultimately is what you can do if employees aren't willing to negotiate.
Firstly, that I picked up for Natalie, you mentioned about the health and safety concerns, and of course, Paul touched upon those health and safety concerns. I'm just thinking of I suppose my position in terms of where I'm based in another sort of shared office area. Whose responsibility is it for that cleanliness? Is it the landlord, or is it the business that is in a shared office space, for example?
So do you share with someone else? What do you mean? So
there's like a common area, and there's other meeting sort of spaces across the.
It's going to depend on the terms of the lease, really. Yeah. But I would expect probably a tenant, that whoever's named as the tenant. But your employer, as Paul said, is probably going to have obligations to you as well. Yeah. So I think the health and safety aspect is going to come from a number of avenues, really, a number of areas.
Absolutely. Okay. No, that's interesting. Okay, that's answered my question. So, Jessie, we can move on to the next question for me. So, Lisa Evans: can someone enter into a consultation period for redundancy whilst on furlough? How does the no work rule apply to consultation meetings? I must say, these are fantastic questions and very, very detailed. And Paul and Natalie got their work cut out on this.
Well, yes, you can enter into consultation while they're on furlough, because that's not work. Simply consulting with employees about redundancy or about anything else is not them doing their job. So it's not work. So that's fine.
Okay.
And it can be done remotely to comply with the guidance on social distancing over the phone or by some form of video conferencing.
Yeah, picking up on that point, I suppose from both of you, how do you think that remote working will change the way you have those discussions with your staff? Because I suppose it's a very different, although we can see each other and you can interact, I suppose it's quite a tough way for employers to talk to their employees about quite serious, and worrying aspects of their jobs. Have you found businesses are asking you for advice on that? And is there any advice you could give?
Well, normally we would encourage employers to deal with these things on a face-to-face basis because it's much more personal. Clearly, as far as possible, that's not really appropriate at the moment, and keeping everyone safe has to be the priority. But it'd be interesting to see how this goes. Actually, I wonder if doing things remotely might sometimes take some of the heat out of what could be quite emotional situations. But time will tell.
Yeah, I think I agree with that. I would say that staying safe is the primary objective, and I think it's a funny one, really. It's personal but impersonal at the same time. And I agree with Paul. I can see how it would remove the heat out of the situation, really. Hello? Absolutely.
No, sorry. It's I'll just jump off screen for a moment. So yeah, we'll go on to but I think it's a fair point, and I absolutely agree, and that's good advice there from both. Next question from Kylie Talbot. Would it be advisable at this point in time to write to an employee who has less than 2 years service and confirm that following the end of furlough, we will have to terminate their employment? Would this go against any furlough rules?
Well, the short answer is no. It doesn't go against any rules. There are no strings attached in that sense, although it's not what the government would have intended, but it doesn't go against the rules. And I think I would encourage you to start thinking now about what you will do when the furlough scheme ends, and start planning for that, because then you can start consulting with employees, especially those with more than 2 years service, and you can give notice. And at the moment, some of our clients are given notice to end people's employment at the end of June, because that's when currently the furlough scheme ends. If the furlough scheme is continued, you could always push those notice dates back. But of course, after that, the government's contribution might be reduced from the 80%. So you might have to agree with the employees that they will accept that reduced contribution in return for their notice periods being extended.
Okay. Okay, brilliant. We'll have two more. I know there's quite a few questions coming, which is great. If there aren't any questions that haven't been answered, we will make sure that the speakers get them and can answer on separate areas. So, second, if asking someone on furlough leave to return to the workplace, do you have to give them notice to return, or could you ask them to return on their working day, for example?
You can ask them to return immediately. They're still employed. The contract of employment still applies. So as long as it's a working day, you could ask them to return to work immediately. Okay, brilliant. And we'll have this last question. I've been advised in a few different places that post-COVID-19, we should all be adding short-term working and layoff clauses to our employment contracts. Is this right/ethical? Would people in sectors that don't usually use these types of clauses feel okay asking their staff to agree to contracts with them in? Paul again. Well, the first thing we did when this all kicked off, which of course was before we had the furlough scheme and clients were already struggling, was look at what their contracts of employment said. And as luck would have it, in the contracts that our standard contracts that we provide for clients, we do tend to include clauses on short-time working and layoff. Clients might not have had any expectation of using those clauses, but as the last 2 weeks have shown, you never know what might happen. So those clauses have proved very useful. And so in future, I think you should put them in, even if it's in a sector where you wouldn't normally rely on them, because who knows what the future might hold. And if employees refuse to sign them, well, you can just discuss that with them on a case-by-case basis. But in my experience, most employees are willing to sign their contracts when they start work. They just sign what is put in front of them, frankly. Yeah. And I wouldn't consider that unethical. If anything, it's just sensible in the light of recent experience. Yeah, absolutely. Okay, and we'll have a last question from Guy Edwards. In construction, we will initially be faced with logistics issues, one person per vehicle.
Where do we stand regarding refusals or unwillingness for employees to get themselves to work? We do have a clause in our contracts that requires employees to get themselves to work.
Well, it's great that you've got a clause in your contract requiring employees to get to work. But even without that clause, I think for any employer, the expectation is it's for the employee to get themselves to work. Ultimately, if they can't get themselves to work, it's their problem. So you could say, well, you're not going to be paid if you don't come to work. And, you know, if you get really frustrated, you could even say, if you can't get yourself to work, then we may have to terminate your employment. As I say, it's really the employee's problem.
Yeah, absolutely. I suppose there is that understanding, isn't there, is that these are very difficult times, and I'm sure the majority of employees will be understanding. I suppose is there when yourselves come in is that when there isn't that understanding and that communication, I suppose. But yeah, I suppose that's you would hope, wouldn't you? And you would like to hope that many employees are understanding of the situation and are trying their level best, I suppose.
Well, that's right. I think most of our clients have done what they can to try and support their employees. But equally, it cuts both ways in a sense. You know, we need employees to be flexible as well.
Absolutely. Brilliant. Well, we'll just finish off with a few sort of key takeaway points. Appreciate, Natalie and Paul, your presentations. I think really detailed, really interesting, and hopefully a lot of the people on the call today will have either had their questions answered or will have had them specifically by the speakers, or have had them answered through the presentation. So, Natalie, if I could just give you 1 minute just to sum up in terms of perhaps the three key takeaway points that you have as a commercial law specialist, and what our businesses on the call should be taking away with them.
So I think what I've said throughout, and I've said to clients, is open and frank discussions. Don't be afraid of broaching the topic, because I think a proactive approach is the best approach to take. Consider all options in terms of easing any financial burden, and consult professional advisors. I'm not just saying that from a legal point of view, but you know, tax specialists, can you claim any refunds, any rebates? Accountants, they should hopefully be saving you money. All that kind of thing, and follow and keep up to date with government guidance as well. I think, because it is changing daily. I appreciate that. But keep up to date.
Is the constant changes, but again, he's keeping informed. And I think what I've certainly found in general is our members, but businesses across the Greater Birmingham and probably the whole of the UK have been really good in offering advice for free, essentially, a bit like this, which is giving people that understanding. And then obviously the more detailed discussions are obviously taken offline and discussed with those who know about it. So really good. Thank you, Natalie. Paul, just to finish off again, your key takeaway points.
Well, number one, continue to make use of the furlough scheme. You know, make the most of it. Really, it's not every day that HMRC is offering to give us money rather than the other way around. So you may as well make the most of it. Secondly, continue to follow the government guidance. That will keep evolving, and I think especially on Sunday it's going to evolve. But from a legal point of view, if you're following the government guidance, it's going to be pretty hard for a court to or a tribunal to criticise you. And finally, I'd agree with what Natalie said. Just keep taking advice, whether from your solicitor or from your accountant. That will make sure you don't get things wrong and risk claims from employees or landlords or anybody else. But also, you know, professional people can point you in the direction of opportunities and lots of support that is out there. So we want to help you.
Yeah, absolutely. No, that's fantastic. And I think I suppose very much the Chambers line has been in line with that area. Is talk to us, engage with your contacts, engage with each other, and you may then, one conversation might mean that you don't end up in a situation where it's very you're a bit further down the line and you've got real issues on. So no, fantastic. Thank you so much both for your engagement. I hope everyone has got what they would like from today's webinar. We're just about on time, with a minute to go. So from my side, if there are any other questions, is there any other information, please get in touch with Paul or with Natalie offline. I think you will likely have their contact details, maybe through LinkedIn, through the areas. But I think really appreciate that there'll be some more themes come up, and we will get the slides over, if that's okay with both speakers. I'm sure it is. The webinar will be publicised on YouTube as well early next week after the bank holiday. So again, we'll make sure that's publicised and people could read back on that. A huge thank you from everyone at the Chamber of Commerce for the engagement here today. Thank you to Natalie. Thank you to Paul. Also, thank you to Jess in the background, making sure that this runs as smoothly as it could. Apologies for the slight delay at the halfway through Paul's presentation, but I think, again, it's really quite inspiring that we've got such good businesses in our locality that are able to give such positive advice, give their time as well, and hopefully help people along the way. Hopefully Sunday brings some positive news, whatever that may look like as we move forward. And we look forward to seeing you all soon. And thank you, Natalie and Paul. And I'm sure I'll speak to you soon as well.